This podcast episode reflects the opinions of the hosts and guests and not of Greenberg Traurig, LLP. This episode is presented for informational purposes only, and it is not intended to be construed or used as general legal advice nor a solicitation of any type.
Hello, everyone, and welcome to the first installment of Greenberg Traurig's Trends in Patent Litigation podcast. This is also the second installment in GT's Delaware miniseries. So we're going to be looking at patent litigation trends with a particular focus on Delaware today. Our topic today is venue. One of the first decisions a company has to make once it decides to bring a patent infringement action is where to bring it. And today we're going to explore that decision. And in particular, we're going to look at two things. First, the thought process a company makes when considering where to sue its competitor. And that focus is going to be primarily on jury trials, not other cases like ANDA cases, which involve bench trials. And second, the thought process a company makes when considering where to file a declaratory judgment action against a patentee that has threatened it. I'm your host, Ben Schladweiler, a shareholder in Greenberg Traurig's Wilmington, Delaware office. I've been practicing patent litigation for over 20 years. I've been involved in cases throughout the country in all the patent-heavy districts, but I have a particular focus here in Delaware where I have litigated over 300 litigations and been involved in numerous trials. I'm joined today by two of my colleagues who I have had the pleasure to work with previously here in Delaware. Josh Raskin, a shareholder from our New York office, and Matt Levinstein, shareholder from our Chicago office. So could you two introduce yourselves, provide us, our listeners, with a little bit of your background, starting with Josh?
Yeah, thanks, Ben. So as Ben just said, I am a shareholder in the New York office. I have been practicing IP law for almost 30 years now, which is scary to say out loud, but it's been a long time. I've done all areas of IP, but I've spent the bulk of that 30 years doing patent litigation. I'm the chair or the co-chair of GT's Global Patent Litigation Group. I'm also the chair of the New York IP group. My practice is generally in the high-tech side of patent litigation as opposed to the pharmaceutical or life sciences side. My cases are mostly in the software space or light electrical, some medical device cases. I practice throughout the whole country, but a large amount of my cases are in Delaware. And Ben, you and I work together on a lot of those cases. Right now, you and I have at least two cases pending in Delaware. There might be more, but it's a place where I am frequently finding myself. And so I'm looking forward to discussing the issues that we're going to touch on today.
Perfect. Matt?
Thanks, Ben. Glad to be here. Thanks for including me in this. Like you and Josh, I'm also a patent litigator. I have 15 years plus experience in patent litigation, based in Chicago, but as many as patent litigators find, my practice is all across the country. I've litigated in here, in Texas, California, and most importantly for today's conversation, Delaware. Like Josh, I focus mostly on high-tech software, shy away from some of the life sciences and pharmaceutical work and patent litigation. But I have had a wide variety of industries and products at issue. So looking forward to discussing these topics and really digging into Delaware venue.
Perfect. So before we get started, I'd like to set the table with where patent litigation is generally more nationally. Nationwide, after there was a sort of initial patent boom in the 2000s, which lasted for quite a while, the number of patent litigations has been steadily decreasing. So from 2013 to roughly the early 2020s. More recently, that trend has switched and the number of patent litigations have been increasing. This is data from the U.S. courts website. For instance, from March 2024 to March 2025, there was a 24% increase in a number of new patent cases filed year over year. And most of that was driven by the increase in NPE suits, which in turn can be traced a lot to the change in IPR reforms. Fewer IPRs being filed and instituted generally means there's more patent litigation. Competitor cases, which again is what we're going to be focusing on primarily today, have also increased year over year, although at a lower rate. According to IP Watchdog, from 2023 to 2024, competitor cases increased about 16%. That's just to give you some background on where we are nationally. Now, with that background, Matt, can you talk a little bit about where people are filing their patent infringement cases?
Yeah, sure. So it will come as no surprise to anyone that Eastern District of Texas was the number one jurisdiction in 2025 in terms of new patent cases filed. Coming in right behind ED Tex was Delaware and Western District of Texas, tied for second, and then in third was the Northern District of Illinois. But those rankings don't really give you the whole picture that Ben has already alluded to. While the Eastern District and Western District of Texas are the top jurisdictions for NPE or non-practicing entity filings, that's different in Delaware. And yeah, Delaware gets its fair share of NPE cases, but really, you might be surprised to learn that Delaware is the number one jurisdiction in terms of competitor cases and declaratory judgment actions. And so I think that's an important topic that we should explore about why there's this difference between NPE activity and competitor case activity in Delaware and elsewhere.
So, Josh, what do companies look for when they're decided to file a case against a competitor and they're looking at where they're going to file?
That's a great question, Ben, and it's actually a timely one for me. I am an adjunct professor at Brooklyn Law School, and my first class, we covered standing and declaratory judgment actions. And the class I'm teaching today, we're covering jurisdiction and venue. So all of this stuff is kind of at my fingertips. So when we advise our clients on where to bring suit, there are several things that clients generally are concerned with or are focused on. I'll touch on three of those things. So first and foremost, it's predictability. I think the three of us know from our many years of experience that litigation is inherently unpredictable. Clients know that as well. We might think that our client has a virtual slam dunk case, but at least I will never tell a client that you have better than a coin flip's chance of winning. And that's not just to manage expectations. I believe that's true. Judges just simply tend to get it wrong. Juries certainly get it wrong. So what we're trying to do when we advise our clients on where to sue is to minimize that unpredictability. And Delaware is a great place to do that. One reason is because of the judges. The judges in Delaware simply know patent law. And listeners might be surprised to learn, or maybe they might not, that most judges across the country do not have any experience at all with. Some have never seen a patent. It's the exact opposite with the judges in Delaware. They have had many, many cases and therefore have developed a deep knowledge of patents and technology. They've developed their own patent rules, which give predictability to the litigations that happen there. So you know how the litigation is going to be paced and you have a general timeline for the case. All of the judges previously were litigators themselves and in fact litigated patent cases. So when we recommend Delaware to our clients, I generally say that if you want a judge who's going to be fair and who's generally going to try to get it right, Delaware is a great place to go. Now, I'm not saying that other judges across the country don't try to get it right, but in Delaware, you generally get that. And judges really try to reach the correct conclusion. The other thing that, in addition to predictability, the other thing that clients look for and that we look for as our clients' lawyers is a jurisdiction where the case is going to stick. And what I mean by that is that most of the time when you're filing a lawsuit against a competitor, the expectation is that your competitor or the defendant is going to try to get the case moved to a jurisdiction that's more favorable to it. It'll file a motion to dismiss for lack of venue or for convenience purposes. And so you want to make sure when you choose a jurisdiction that you're going to choose one where you have the highest likelihood of staying. And Delaware is a great place for that as well. The main reason for that is that after the TC Heartland case, which was a Supreme Court case that clarified venue in patent cases, you always have venue over a defendant in the jurisdiction where that defendant is incorporated. And as most of our listeners will know, Delaware is the highest state of incorporation for tax purposes and other reasons that go beyond the scope of this podcast. But there's a high likelihood that when you're looking at ties to a particular jurisdiction, that your defendant is incorporated there. And once you see that, you know that you can file in Delaware and stay in Delaware. And then the last thing that I'll talk about with regard to choosing a jurisdiction is, of course, the ability to win. You want to choose a jurisdiction where your client has the highest likelihood of victory. And statistically speaking, the win percentages in Delaware are higher than any other of the patent-heavy jurisdictions. In fact, the win percentage in Delaware for patentees is 15.5%, which is at least a couple of percentage points higher than the districts in Delaware and Northern District of California.
Thanks, Josh. And speaking of winning, another consideration is obviously sort of the quality of the win. And what I mean by that is, will you be able to achieve your ultimate goals, whether those goals are receiving compensation or enjoining your competitor? The ability to achieve those goals is obviously a big consideration in deciding where to bring your lawsuit. No surprise, compensation is sought in the vast majority of competitor cases. And so the ability to get compensation that you feel you deserve is obviously very important. Looking at some of the overall damages trends nationwide, and this is coming from a 2024 IP watchdog study, over the last 20 years, damages numbers have trended downwards, which is a little bit surprising, but it is the case. And most of that is caused by reductions in the awards given in non-practicing entity or NPE cases. Damages awards to operating companies during that time period have remained steady. The study also showed that operating companies are the ones who are getting the awards, and that makes sense because, for instance, over the last 2 years, 77% of the cases in which damages awards were awarded were competitor cases. And you get a better chance of obviously getting to trial and getting an award as a competitor. So those stats sort of make logical sense. Turning to Delaware, the damages awards in Delaware do compare favorably to other patent-heavy jurisdictions. In fact, this is again from IP Watchdog, Delaware has the top spot amongst competitor-heavy jurisdictions, meaning Northern District of California, District of New Jersey, Northern District of Illinois. And out of the top 10 damages awards for 2025, 2 of them came from Delaware. So what are some of the reasons for this? Part of it is driven by the jury pool. Delaware has a lot of banks and pharmaceutical companies who reside here. So you generally get a lot of finance and technical people on your jury. In fact, a 2018 study from a trial consulting firm found that 10% of the jury pool in Delaware works in finance. If you compare that to, for instance, Marshall, Texas, which is part of the Eastern District of Texas, that percentage is only 4%. So it's a significant difference there. It's more than double the percentage of finance jurors that you would have here in Delaware that you would get in Texas. And obviously, finance people are used to high damages numbers, are used to high numbers just generally. And Delaware also has similar rates as far as once willfulness is found, it's up to the judge whether or not the damages are enhanced. And typically, Delaware judges enhance those rates similar to other jurisdictions. So the takeaway is, in looking at the quality of the damages awards, Delaware certainly holds up to the other patent-heavy jurisdictions, and in fact leads the competitor-heavy jurisdictions in many aspects. One last consideration that I mentioned before is, can you achieve your goal of enjoining your competitor? Because obviously plaintiffs often want to do that, either preliminarily where they're seeking an injunction, pending an ultimate outcome in the case, or seeking a permanent injunction after trial. Delaware has lots of experience handling these injunctions. In fact, it's handled significantly more injunctions than all of the other patent-heavy jurisdictions. Now, just to give you an idea, these numbers that I'm about to give you come from Docket Navigator. But in the past 10 years, Delaware has presided over 160 preliminary injunctions, TROs, and permanent injunction motions. To give you an idea of how that compares to Eastern District of Texas and Western District of Texas, they've only had orders of magnitude less. And so likely this is a result of Delaware handling more competitor cases and trials. But as a result of that, handling more injunctions, most Delaware judges have an established process also for dealing with such requests. So, for instance, you're quick to get in order setting a hearing or briefing schedule. And so your motion, when you file it, typically gets prompt attention. You also have certainty in the process. And what I mean by that is you have certain expectations. You should expect that your declarants will get deposed. You should expect some document discovery, and you should expect that you will likely not get a full evidentiary hearing. Rather, you're going to present at your case at oral argument. As far as success rate goes for preliminary injunctions and TROs, they're very difficult to get in every jurisdiction. Delaware is no different, but Delaware does have, if you take away Eastern District of Texas and Western District of Texas, they do have a higher success rate, which is expected because they're obviously patent-friendly jurisdictions, but Delaware has similar success rates than the other competitor-heavy jurisdictions. So the takeaway, again, is Delaware has more experience than other jurisdictions with these type of motions, and its success rate is comparable to the other patent-heavy jurisdictions out there. So, Matt, given that, can you walk us through what can a plaintiff expect once they file a case in Delaware?
Sure. Ultimately, plaintiffs can expect a clear, relatively fast path to trial with the case milestones and stages like Markman, summary judgments, and, if necessary, mediation, designed in a way to produce defensible results. And so the best place to start, I think, is with the case timeline itself. When people think about speed in patent litigation, I think they ordinarily think of Texas. And that makes sense because the Texas courts do move fast, faster than Delaware, in fact, to trial. But here's the part that actually might surprise some of our listeners. If you're talking about competitor as opposed to NPE cases, Delaware is a fairly fast venue. Delaware's average time to trial is 37 months. Which is several months faster than the Northern District of California and years faster than the Northern District of Illinois. That being said, it is about a year slower to trial relative to Texas. But that's only looking at one part of this. We can't just look at the time to trial. What is a plaintiff going to expect in terms of time to final disposition? And so while Delaware is quick to trial, it's actually relatively slow to final disposition. And what that means is that cases filed in Delaware hang around for a while, and they have a strong possibility of actually making its way to trial. And this is generally desirable for plaintiffs. And this is what we tell would-be plaintiffs who are considering whether to file in Delaware or not. It's desirable because it means that early exits are hard to come by for defendants. Defendants can't just count on obtaining a quick dismissal or some early procedural win. To summarize, Delaware courts tend to let the cases develop, which means the plaintiffs who have real claims, they get a lot of runway to pursue their cases. And so if we look at one of the first case milestones, it's going to be Markman. And here's what plaintiffs can expect as part of the Markman proceedings. In Delaware, Markman typically starts a few months into fact discovery, and the courts will allow both fact discovery and claim construction to proceed simultaneously. The court will usually schedule a Markman hearing during fact discovery and generally issues opinions 60 to 90 days after the hearing. And what's important to note here is that Delaware judges try to issue Markman orders before fact discovery closes and before final contentions are due. And what this means is that there's still time to develop the fact discovery you need and tweak the case in light of the court's Markman ruling. It's also worth noting that with respect to the concept of plain and ordinary meaning constructions, Delaware is somewhat unique in that the judges frequently don't let parties, and plaintiffs in particular, to rest on constructions of just plain and ordinary meaning. Instead, the courts will generally push the parties to explain what those plain and ordinary meanings are. And the reason for that is that the goal at Markman in Delaware is true clarity of claim scope. And this goes back to what Josh and Ben were saying earlier. What you get when you go to Delaware is predictability. You don't get a fly by your seat of your pants type of Markman ruling. You get a Markman ruling that's going to stick through trial. There won't be placeholder plain and ordinary meaning constructions that will need to be adjusted later on. You get what you get at Markman, and the parties can feel confident that that will be the claim construction that is going to govern the rest of the case. The next milestone is summary judgment in Delaware. And in Delaware, it shouldn't come as a surprise based on what you've heard so far that it's hard for a defendant to win at summary judgment. In fact, Delaware has one of the highest summary judgment denial rates of the patent-heavy jurisdictions. And it's around 70%, depending on how you characterize partial grants and partial denials of summary judgment. And on top of that, it's even harder to get early summary judgment in Delaware. Only 20% of the motions filed where a party is asking for leave to file an early MSJ have been granted in Delaware over the last 5 years. So what this means as a plaintiff is you can feel relatively confident that unless there is a very clear basis for a defendant to obtain summary judgment, they're not going to win it early, and there's still a low chance of them winning it during the ordinary course of summary judgment proceedings. And so our listeners might be wondering why Delaware has become this jurisdiction where summary judgment goes to die. And there is one, let's call it a procedural peculiarity that some of the Delaware judges use. And what some of the Delaware judges use is they require parties to rank their summary judgment motions in the order they want the court to consider them. And so when it comes time for the court to consider summary judgment, if the court grants the highest ranked motion, then it moves on to the next highest ranked motion and considers that. But if at any point in time the court denies the motion, it will deny all lower ranked summary judgment motions. And so what this means is that you need to be real careful about how you order your summary judgment motions and what you ultimately decide to bring as summary judgment. So again, this is just another way that Delaware courts pave the path for plaintiffs to have a jury resolve their dispute. And finally, the last point I want to make, and I will touch on it just briefly, is about mediation. Along with this same theme that trial is a realistic outcome for a competitor case filed in Delaware, Delaware judges no longer automatically grant early mediation with a magistrate judge. Now, of course, you can ask for it, but you might not get it. And the reason for that is the Delaware judges know that in a competitor versus competitor case, an early mediation is not likely to produce a settlement without a claim construction order. So the judges just aren't all that interested in granting a motion for early ADR.
Thanks, Matt. Yeah, I know from experience how hard it is to get early summary judgment in Delaware. Usually you don't get that unless you actually give something up. For instance, you tell the court that this is going to be your one and only shot at summary judgment. So really it makes you think before you file your motion. Our focus, I'm going to switch gears a little bit. Our focus up until this point has been on competitor cases, but I also want to talk a little bit about where a company files a declaratory judgment action after being threatened by a patentee. Many of these same considerations we've been talking about come into play. But Josh, what does an alleged infringer look at when considering filing a declaratory judgment action?
Yeah, thanks, Ben. And you're correct that some of the considerations that I discussed earlier, predictability, ability to stick the cases, ability to win, of course, those all apply to declaratory judgment actions as well. But for me, when I'm advising clients on where to file DJ actions, and this is especially true because, as I stated earlier, much of my practice focuses on software type cases where we oftentimes have a good argument under Section 101. And for our listeners who aren't familiar with Section 101, Section 101 of the Patent Act states or sets forth what is considered patentable subject matter, right? So what can be patented, what is able to be patented without regard to prior art, just what subject matter can one patent? And one of the things that are carved out from patentable subject matter are abstract ideas. And since the Supreme Court's Alice decision, one very powerful tool that an alleged infringer has is to claim that the patent should not have been granted in the first place and violates Section 101. So when looking for a jurisdiction in which to file a DJ action, we like to choose a jurisdiction where we feel comfortable that the judge is not going to be afraid to invalidate the patent. And, that may sound obvious, but there are certain judges, and especially judges who don't have experience in patent cases, who may find that they need to be really convinced if they're going to be asked to invalidate a patent. And so what we do is look for jurisdictions where there's a track record of invalidating patents, especially on 101 grounds. And Delaware fits that description. Statistically speaking, Delaware has considered more 101 motions than any other jurisdiction and has granted more 101 motions than any other jurisdiction. What I mean by 101 motions, if you're going to challenge a patent because it violates Section 101, the best time to do that is right at the beginning of the case pursuant to a Rule 12 motion. However, certain judges across the country, and I won't name names, are highly reluctant to consider Section 101 at the outset of the case. They'll claim that there needs to be discovery or there needs to be Markman before they'll decide 101, but that's not the case in Delaware. In fact, in Delaware, the judges have come up with what I think is a brilliant process for considering 101 motions. At least two of the judges, Judges Andrews and Burke, and I think possibly others, have begun holding what they call 101 days, where they will group together a bunch of cases where there are pending motions to dismiss on 101 grounds and hear them all at the same time. And Ben, I think you and I might have been part of the very first one of those 101 days before Judge Andrews. I won't name the client, but they probably wouldn't mind since we won the motion that day and the decision was affirmed by the Federal Circuit. But they do that, the judges will do that because it'll move the cases along and you don't have to wait for the judges to have a hearing and then write the decision. They will literally have the oral argument, take, a 20, 30-minute break, and then come back in and read their decisions into the record. It's a very efficient way of doing it. It groups cases together that have overlapping or similar issues, so it's efficient in that respect as well. And so circling back to where I began, Delaware is a great place to bring a DJ action if you're going to have a challenge to the validity of a patent early in the case, especially on Section 101 grounds.
Yeah, great. Thanks, Josh. I do remember those early 101 days. In fact, they used to, when early on, they did them as 3-judge panels across a multitude of cases. So it was very fascinating. And they were just trying to figure out 101, early on, just like everybody else was. So thanks. Hope our listeners found this insightful. On behalf of myself, Josh, and Matt, I'd like to thank you for listening and take care.